Car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys, with Josh Wright from the law firm of Hollis Wright and host David Lamb.
Good evening and welcome into the attorneys. Thank you so much for being with us on this Sunday evening. If this is your first time with us, we're awfully glad that you stopped by and decided to join us. The way this works, for the next half hour, we have a panel of experts that are ready to deal with the topic that we believe is of interest to you. But we'd love to have you be a part all throughout the program tonight. There are ways you can join the conversation. You'll see that info at the bottom of your screen. Also, Hollis Wright makes available their attorneys during the show tonight to speak with you. That's a confidential off-air call. Just pick up the phone and give them a call to get some great free legal advice. Now, leading our conversation, he's the managing partner of the firm Hollis Wright. Josh Wright, good to see you. You're looking good.
You look great, too.
Thank you, sir.
Everything going well?
It's all good.
I took a little break away for 5-6 weeks.
You did?
I did.
We had to manage without you, but we're glad you're back.
Well, I'm super happy to be back.
Ship is steady now.
That's right. That's right. You know, we're going to do an interesting show today. We've done many takes on this, but when it comes to accident and injury related issues, it is one of the leading causes of injury and death throughout the country. And so that's why we do a lot of shows on it, because there are a lot of people that are impacted and affected by this. We've done some very specific shows on car accidents or on work-related accidents or product liability claims, those types of things. Today we're going to talk kind of broadly about accident injury related litigation and how that works and what to do if you've been in a circumstance before. And when we talk about this kind of stuff, we try and bring folks that are really good at this area of the law. John Spade with our law firm, who's been with us for years, does an outstanding job, and not only does he do a good job in that area of the law, he does a great job on the show. So first of all, glad you're on as usual. I get to see him every day, so it's all good.
Thanks for having me.
Absolutely.
Always good to be here.
So, you know, this is a big component to what you do in your practice on a daily basis, isn't it, this area of the law?
Absolutely, absolutely. I mean, we only handle personal injury, claims at Hollis Wright, and that's really, actually since law school, that's all that I've done is personal injury work. So this is definitely something that's very near and dear to my heart and something that I deal with on a daily basis.
So some of the statistics that I think are really fascinating, accident-related injuries is the leading cause of death for a vast majority of age groups.
Okay.
And 82% of those accident injuries in those age groups are generally, there are some exceptions, but 82% generally involves males, not females. And that has been fascinating to me when you really start to think through that. And you start to assess why, when you really dig a little bit deeper and look at it, that this category and the way they do those statistics is not just automobile accidents. It is also work-related accidents, construction-related accidents, industrial accidents, and those types of things. And those may be more male-prevalent industries and sectors where males are more a part of these accident injuries. So anyways, it does impact a vast majority of the viewing audience regardless.
For you all in this kind of sector arena of cases, how does it look in terms of what are the cases? What do the cases look like for you all, and how does this kind of live out in the kind of daily life of the firm?
Good question.
Absolutely. We have, of course, your automobile accidents, 18-wheeler accidents, also premises liability, people going and getting hurt on a premises because of a dangerous condition, workers' comp or work-related on-the-job injuries, construction accidents. That's another big area that we tend to handle. And really, it doesn't have to be one specific location. As long as there's a personal injury aspect involved, we usually see if we can help the injured victim any way that we can.
And a lot of this, David, is just an evaluation. There are many cases that John and I see on a daily basis, as do the other 9-10 lawyers at our law firm, where they evaluate a case, do a full investigation, which we do at no cost to the client, because generally we're handling these cases on a contingency fee basis. So it's at no cost to have it investigated. And a lot of times we'll come back and say, look, here are the facts. Here's what the law says. You unfortunately do not have a case the way that we see it. So a lot of these cases never get filed, never get litigated, and are not prosecuted, if you will. And then there are the other cases that we evaluate and say, all right, hold on, here are the facts, here are the circumstances, here's what the law says, we've got some potential claims that we can assert. You, client, need to make a judgment call whether or not you're interested in prosecuting that. We think so highly of this area of the law as a law firm that in the last 12 months, we have brought in a workers' comp lawyer that handles almost exclusively workers' comp, because so many of these accident injury related claims come out of an employment context. And I'll give you a good shining example. You may have an employment related accident. However, there may have been a third party that is not the employer that was responsible for the cause of action, that was responsible for the injury to the worker. Take a crane case. Somebody didn't maintain the crane. And the crane, we have these actual cases right now, and a crane broke and allowed somebody to be catastrophically injured. Well, that's not the employer, it's the crane and the manufacturer of the crane and the person that did the maintenance on the crane. So a lot of times we're investigating that entire claim and saying, all right, you have this workers' comp claim over here that's a no-fault system that we can protect you and we can help compensate you for your lost income and for your injuries. Over here, we have a third-party claim against the crane manufacturer, a third-party claim against the maintenance company that was supposed to maintain that, and a third-party claim against the individual that was brought in to run the crane that over-hoisted weight. And so a lot of times we're evaluating a lot of different things together and then trying to advise the client and lead, guide, and direct them through the process. But like I said, we think so highly of this area of the law that we brought a workers' comp lawyer in Alwyn Horn who does an outstanding job at our law firm just to do those types of claims. And John's involved in a lot of those claims too.
I've got a question here from a viewer. It says, I was recently in an accident where I was injured on someone else's property. I've learned that other people were injured before me due to the same condition. Will this help my case, and if so, how?
It absolutely will help your case. In order to just kind of black letter law, in order for you to even be able to have a claim for premises liability, you have to show that there was a defective or dangerous condition on the premises, and that the premises owner either knew or should have known that the defect in the premises was there. Now, if you have an instance where somebody's hurt prior to your injury, that goes to show that prior notice and that the premises owner was aware of the defect and they either didn't warn properly of the defect or they didn't remedy the situation and make the premises safe for the specific type of person that's on the premises, whether it be an invitee or hopefully not a trespasser, but right, depending on who's on the premises.
Well, and sometimes you can actually be a trespasser and not even know you're a trespasser, right? So we find that in many circumstances with children who did not realize that they're trespassing on somebody else's property. When we think of property claims, we just assume they always relate to a local neighborhood where I know when I've moved onto someone's property or I'm in someone else's pool, whereas a lot of times it may not be in that context. It may be in the context of going on someone's property for hunting purposes, for joyriding, whatever it may be. There are circumstances where they may not realize that they're actually going to be listed as a trespasser, but the standards do change. John, talk for a minute, because I think this is important to lay out the issue of how these claims get investigated at no cost to the client so that they have the same level of legal service that you'd have on the defense side. We've got something unique called a contingency fee contract, and just explain kind of in general how that works.
Absolutely. And so, we're able to take cases on a contingency fee basis, like you pointed out, and what it allows an injured victim who's faced with, medical bills, just this disastrous situation in their life, to go and get legal services and have a competent attorney evaluate your claim, pursue your claim, and if for some reason there's no recovery at the end, that's no cost to them. We front all of the expenses and we take a percentage of the recovery if there is a recovery to be had, and if there's not, at the end of the day, they're not having to come out of pocket and they can still hopefully get the compensation that they desperately need.
David, as you know, years ago I was president of the Alabama Trial Lawyers Association. One of my platform issues was access to justice. The contingency fee agreement allows for access to justice for a lot of folks that couldn't do it on their own financially if there was no contingency fee agreement. And so on the plaintiff side, we are huge proponents of the contingency fee agreement because it does provide access to justice to individuals and sectors and groups that would never have the right and the financial resources to be able to file a suit and pay a lawyer on an hourly basis. So if anybody is facing a circumstance where they've been involved in an accident or injury, I would highly encourage them to contact a lawyer. It doesn't have to be us. It can be any of the many great lawyers in our state that do this type of work related to accidents and injuries. But know that you can work your way through a contingency fee agreement to get great service.
Time for us to step aside.
When we come back, I want to talk about statute of limitations. That's a huge and critical component.
Good deal. We'll pick up right there as we step aside. A reminder of how you can join our conversation. We'd love to have you do so. The information you'll see right there on your screen, ways that you can join us. Also, don't forget, Hollis Wright, really active on social media. Check them out there on all the social media platforms, specifically Facebook and Twitter. You see there. Stay tuned. We're coming right back.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
Welcome back into The Attorneys. Thank you so much for being with us tonight. Hey, a reminder, while we are on the air, attorneys from Hollis Wright standing by live right now. All you have to do, pick up the phone, call that number you see there on your screen, and it's the opportunity tonight, while the show is on the air, to get some great free legal advice. Josh?
Yeah, and I think people sometimes do wonder whether or not we actually return all these calls and emails and texts, and we do.
It happens.
We get some great questions. Questions a lot of times that we'll use on future shows, and a lot of topics come out of the questions that come in. We've seen some new areas of the law developing over the last 2-3 years that have come out of some of the questions we received. So we really do appreciate the feedback, it's helpful, I think, to be able to give the viewing audience a lot of different options to get in touch with us in the environment that they feel comfortable with to ask legal questions. And they need to also understand when they call, text, and email, they can do it confidentially, and it doesn't have to be on the air. And we're not going to promote them, and we're going to answer their questions, which is good.
All fair, confidential, and all you got to do is just pick up the phone and call that number you see there.
And that's what makes our show unique to some of the other shows, is that we have the ability to have that confidential conversation about a real-world issue someone's facing. All right, when we went to break, we were talking a little bit about statute of limitations. I said, let's get into that. Let's kind of unwrap that, because that's important. There are a lot of circumstances where waiting and sitting back is a bad idea as a person who's been involved in one of these events. Isn't that accurate?
Yes, absolutely. And just kind of for the public out there, statute of limitations is basically just a finite period in which you have to file your lawsuit. But to your point, there are some times, depending on who the tortfeasor or the defendant is, that period of time is even smaller, and without meeting some kind of hurdles, more or less, you can bar your claim completely. And that's a notice of claim, for instance. If you're filing a claim against a municipality, you have 6 months from the date of the injury to do that. If it's against a county, you have to do that within 1 year. Now, that doesn't mean that you're not still subject to the broader statute of limitation for personal injury being 2 years. But if you don't, for instance, file that notice of claim within the 6 months against the municipality, then your claim, when you go and try to file it a year, year and a half, 2 years after the injury, is going to be barred because you didn't meet that first kind of procedural hurdle on the front end.
And I think people sometimes, when you use the word bar, and I use it too, kind of like, okay, well, so where do we go file it now? Barred means barred, like
it's
done,
done,
finished,
it's dead.
over.
Yeah.
There are circumstances where our firm, our lawyers, still have a couple other avenues here and there. Sometimes there are some federal claims that can be asserted that are still within a statute period. But if you've missed your window, right, to file that suit or provide notice, barred oftentimes means barred, like you can't pursue it again. And the legislature, in their wisdom, has determined with municipal entities and with county entities that notices of claims have to be presented really, really quickly. There are even circumstances in employment contexts with some of the federal agency where you have to provide notice within 90 days or 180 days of the actual discriminatory act. And so a lot of times, you know, we are jumping on those claims when people call us to say, hey, you don't have a lot of time. And if you wait too late, sometimes, unfortunately, the lawyer says, look, I just don't have enough time to evaluate this.
Right.
So we'd highly encourage people to jump on things.
I bet one of the toughest parts of you all's job, though, is whenever someone does have a legitimate case, but they waited too long and you have to call and tell them there's really nothing we can do. I bet that's a tough call to make.
Yeah, there's no question about that.
It is, and you know, unfortunately, sometimes Alabama does have some strange laws that can kind of cut against your ability to bring a claim. One that kind of jumps out to me is the guest passenger statute, something that we have that's kind of unique to Alabama, where you cannot bring a claim against the driver of your vehicle for just a negligence claim if they cause a collision, for instance, unless you meet one of several exceptions. And talking about tough phone calls, you know, I've been in situations where I've been, you know, representing two children, one being 7 years old, one being 14, and there's ways to get around the guest passenger statute if you're 13 and under, but not if you're 14 or older. Wow. And it's an arbitrary cutoff date, but it can have a disastrous effect on your ability to pursue a claim if you fall into one of those strange categories.
Trial lawyer right here, someone that, you know, evaluates it and analyzes it from a lot of different ways. And sometimes age is impactful, the timing of the accident is impactful, what area of personal civil law it will fall into, what court system you file in. All those issues are pertinent to the success of a claim. So as we say on the show, and I mean this sincerely every time I say it, you know, you don't have to come to our law firm because we've got a television show and we do some advertising on TV. You don't. There are a lot of great lawyers out there, but get to somebody and get to somebody quickly, because there are a lot of firms out there that will do contingency fee-based work like our firm does, that can lead, guide, and direct you through this process to make sure that you're filed on time, in the right location, with the right claims asserted, so you've protected all potential claims.
We got a good viewer question to get to, but while we're on this, let's put on your professorial robes here and teach us something. The difference in the burden of proof in a civil case and a criminal case.
Well, in a criminal case, it's much higher than a civil case. Okay. You got to kind of look at what's at stake.
Right.
In a civil matter, you're going to try to get compensated. There is some punitive aspect if you get to just reckless behavior, but at the end of the day, you're usually looking for money damages. Whereas in a criminal context, you're looking at putting somebody in jail for what could be a long time, or God forbid, maybe even the death penalty. So the standard proof is much, much higher in a criminal context, beyond a reasonable doubt, versus in a civil context, it's just 51%. Just ever slightest in the favor of the plaintiffs, and it's beyond a preponderance of the evidence is a kind of legal phrase, but at the end of the day, it works out to just over 50%, 51%.
And that concept there is to help lead juries to make judgment calls as to what's accurate, what's not. And the best part about being a juror is you get to accept evidence if you think it's credible, and you get to dismiss evidence if it's not credible, if it doesn't meet the standards necessary in the case. And you know, John has outlined that perfectly. The goal has always been, from a constitutional perspective, that we raise the burden in criminal context to make sure that there are no innocent men and women that are convicted, and we're willing to allow some criminals out there, because of such a high burden, to go free, because we want to make sure that guys that are doing it the right way, women that are doing it the right way, are not criminally prosecuted. and don't get convicted of something they should not have been. But the way we explain this just in general terms is I explain it like the scales of justice. They start out even with one another as the case starts. And you fill those scales up with evidence. The plaintiff does and the defendant does. If the plaintiff tips those scales ever so slightly in favor of the plaintiff throughout the entire case, the jury must award damages in that case. They have a lot of different options, and the jury will, or the judge will guide them through that. But if you meet your burden, the verdict should generally be in favor of the plaintiff. And so, you know, that's just one of the things that we have to explain to clients a lot. When we come back, because I know we're getting ready to go to break, I want to talk about how regulation in Alabama and nationally has actually helped reduce injuries. Let's talk about
regulation for the good. All right, we're stepping aside. This is our final break of the evening. As we do so, just a quick reminder how you could join our conversation. You got a few minutes to do so, so take advantage of that. Stay tuned. More of the attorneys coming right up.
I'm attorney Carter Clay with Hollis Wright Law Firm. If you've ever been involved in a civil lawsuit or been a witness to an accident, then you may have been asked to give deposition testimony. In this week's Legal 411, we are answering the question, what is a deposition and why am I being asked to give one? Depositions involve the process of a person giving under oath testimony that is outside of court. The person giving deposition testimony is referred to as the deponent. Depositions are taken in the presence of a court reporter, and the court reporter records the testimony. After the deposition, the attorneys for the parties received a typed transcript that contains all the questions that were asked by the attorneys, as well as the answers given by the deponent. The purpose of taking depositions is to ensure that the attorneys for the parties have a full and complete understanding of the events giving rise to the lawsuit, as well as an understanding of the testimony that they can expect to hear from witnesses at trial. Another reason an attorney might want to get deposition testimony is that it allows the attorneys to better prepare for trial and to develop a strategy for presenting the case to a judge or a jury. At trial, the deposition testimony can be used in several ways. First, if a witness on the stand deviates from the deposition testimony, an attorney can use the deposition to impeach the witness. Also, if a witness forgets certain facts or events, the deposition can be used to refresh the witness's recollection. Finally, in some instances when a witness simply cannot attend trial, the trial judge has the authority to allow the deposition testimony to be read to the jury. If you are a party to a lawsuit and are requested to give deposition testimony, your attorney will likely spend a significant amount of time preparing you for the deposition process to put you at ease and make you feel comfortable. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys on WBTM 13.
Welcome back into The Attorneys. Just a few minutes remain, and if you want to take advantage of that opportunity to speak with an attorney standing by live, pick up the phone and give them a call now. Josh?
So, you know, that firm fact, it's interesting, that firm fact really leads us into this issue of regulation, and that's an example of OSHA. John, talk just for a minute about how some regulations have actually helped, for example, in the employment context, kind of reduce injuries and help workers be safer.
Absolutely. So OSHA, since it was enacted, job-related accidents have actually gone down 60%. So it is doing a lot on the front end to make sure that employers are compliant with just some safety regulations so that employees are working in a safer environment. So we definitely seen definitely an uptick in just a safer workplace for the employees.
Yeah, and a lot of times we're working hand in hand with OSHA and their investigators, with our investigators, to determine what was the cause and contributing cause to an event. OSHA fines employers. Those fines can have major implications in the lawsuits that we may bring, and it also may highlight who the responsible and culpable parties are in a specific event. Another good example is the FDA and the medical device component of the FDA that helps to make drugs and medical devices safer, requires certain trials, certain medical equipment to go through certain testing before it goes to the market. So there are a lot of examples of circumstances where regulation has made things a lot safer and where we're following the regulations to make sure if somebody didn't do it the right way that we're holding them accountable. There's no question about that.
Yeah. A quick question we've got here. I was recently told that if I pursue a personal injury claim, I may have to reimburse my health insurance company for what is paid to satisfy legal bills. True?
Well, good question. Go ahead.
Yes, you likely will. When you sign your health insurance contract, there's a provision in there that's called a subrogation provision. And what it says is if you recover from a third party as a result of medical bills that the health insurance pays for, that you have to reimburse them. Now, there's ways that attorneys can negotiate reductions off of that, and of course, your health insurance provider's not paying dollar for dollar. Say you go to the emergency room and it's $10,000, they might pay $100.
Right.
But a portion of that will go to repay the health insurance provider.
And people sometimes really struggle with that, and they're like, I don't understand why we have to pay these folks back. And the reality is, let's take a major medical provider or insurer in our state, and we all know examples like Blue Cross Blue Shield and some of the others. But it's also not their fault that you were involved in an accident, right? It's somebody else's fault, and so that person's insurance company, that person should be responsible for compensating not only the injured victim, but also the health insurer that had to pay that money back. So it's a sound reason. Right. There's a sound reason why we have to do that.
We're just about out of time, but time enough for both of you to give a final thought. And John, if you would, you go first, please.
Yeah, thank you all for having me on to talk about something that's definitely near and dear to my heart. I know we say it a lot, but every personal injury case is different. And the sooner that you get an attorney involved, the better.
Yeah, Josh.
And because the statute of limitations running, you need to get somebody involved quickly. The reality, though, is this. I think we provide, and other plaintiff lawyers that do contingency fee-based work, the same level of service you're going to get on the defense side. Don't be afraid to pick up the phone, call, text, email, whatever. Have a confidential conversation with a lawyer where you can assess whether or not you've got a viable cause of action. Sometimes people are just intimidated by the system. Don't be. Lawyers can help you, and they can also lead, guide, and direct you through the process.
That's awesome. Appreciate both of you being with us.
Absolutely.
John, good to see you again.
Good to see you as well.
We'll see you next time. Thank you for joining us as well. We always appreciate it, and we'll look for you next time as we wrap things up. The firm, you can still get in touch with Hollis Wright. Here's how you can make that happen. Thanks again, and we'll look for you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.